A Florida family shattered. A mother fighting for her life, two innocent children gone in an instant. And the woman allegedly behind this tragedy, police say she tried to run from it all. Here's what happened. A mom was pushing her babies across the street, then out of nowhere, headlights, impact, and screams that were allegedly ignored. Sarasota police say the driver didn't stop, didn't check, or call for help. Instead, she allegedly drove off, reportedly disappearing. I'll walk you through what happened. For Law and Crime News, I'm Kennedi Walker. According to Sarasota police, 72-year-old June Fenton was arrested for hitting a family with her car, killing two young boys and leaving their mother in a coma. And allegedly, she was unaware of the unimaginable loss. The boys were just 2 and 5 months old. Their family shared in their obituaries that 2-year-old Rio loved trucks, swimming, playing at the beach, and being with his family. Baby Kiylen loved his bottles, rolling over and cuddling with his mom. The boy's mother, Taeler Bennett, remains in a coma. According to the last update on the GoFundMe page set up by her family, she suffered a traumatic brain injury. The 29-year-old also has 2 daughters that were not involved in the crash, but are now left to grieve the loss of their brothers. Now let's take a look at what happened that night. According to the Sarasota Police Department, on February 10th, around 8:30 p.m., Taeler Bennett and her sons were crossing the road. Her 5-month-old was in a baby carrier on her chest, and her 2-year-old was in a stroller. As they crossed, a Lexus, who police say was driven by June Fenton, plowed them down. Assistant State Attorney Joshua Wortham reportedly told Fox 13 News that Taeler was allegedly thrown into the hood of the vehicle, then slammed into the windshield, which caused it to shatter. But instead of stopping the help, Fenton allegedly fled the scene, came back, and then left again. The state attorney's office said Fenton turned around and drove back to the scene of the crash, but as Bennett and her boys laid in the middle of the road, she drove off. After weeks of searching and asking for the public's help, police were able to track down and arrest June Fenton. Investigators were able to track her down by allegedly using a piece of a broken headlight collected at the crash site. Detectives took that piece to a local Lexus dealer to determine which model the headlight could have come from. According to WWSB, that's when detectives went door to door looking for the potential model and the driver. And that's when they found Fenton. This video obtained by Fox 13 shows Fenton's first court appearance. She arrived to court in an orange jumpsuit. Turns out the retired hospice worker was allegedly out feeding stray cats before the crash happened. Fenton's defense attorney argued that the 72-year-old thought she hit a dog. Fenton was arrested on 2 counts of leaving the scene of a crash that resulted in a fatality and 1 count of leaving the scene of a crash that resulted in serious injury. The judge set Fenton's bond at $650,000. And joining me to speak more about this story is legal expert Patrick Provenzal. Patrick, thank you so much for coming on today.
Of course, Kennedy, thanks for having me. I look forward to talking about this case with you.
So given the charges that Fenton is facing, how much time could she serve if convicted?
So the answer to that is a bit complex, but from the simple, straightforward end, the sentencing guidelines in Florida for this kind of an offense where you have both very tragically 2 people who passed away as well as someone who's in a coma. There's a minimum of 4 years in prison as a penalty, but because of the number of victims, that normal cap for that level of offense, which would be 30 years, could be increased substantially. Florida law allows for consecutive sentencing under certain circumstances, one of which is where there are multiple victims, and certainly I think that's open for the court to consider when sentencing if she pleads guilty or is found guilty.
Does Fenton's decision to flee the scene impact her case?
Well, it certainly impacts her case to the extent that it meets one of the elements of the crime, right? So she's charged with leaving the scene of an accident involving fatalities and severe or serious bodily injury. So the fact that she fled means that she did not meet the obligations under Florida law that where there is an accident, you are required to stay behind and either provide aid or contact first responders or the police in order to report what happened. The only other thing I was going to add is that the fact that she fled also will be important in the prosecutor proving to the jury or to the court what her intent was, what she knew at the time, because the statute requires that her having left the scene be done willfully, and certainly her going back to the scene and then learning more information about whatever it was that she struck is going to be very important for the prosecutor to point out that she either likely knew or should have known who and what she hit.
Now, her attorney is claiming that, Fenton thought she hit a dog. How might that claim affect the case legally?
Well, it's going to affect it in a couple ways. So the first way it's going to affect it is that obviously it goes to the heart of the charge, which is that she willfully left a scene involving injury to a person or death of a person. So that defense is directed at pushing back on the allegation in the charges that she knew who she hit and she left the scene. The second is that, depending on how the rest of the case plays out and what the police and prosecutors can prove, it will likely be used at sentencing to try and explain some mitigation on the part of her to reduce the punishment. Because her lawyer's argument at sentencing will be she just wasn't certain. Maybe she thought it was a dog, maybe it could have been people. And under that situation, in those circumstances, in the stress of that, she just panicked, and that it wasn't really a malicious intent of her leaving the scene, but that she was just in either a fog of what had just happened and what she had experienced, and the doubt about what it was that happened that led her to leave.
Now, her bond was set at $650,000. What is the legal argument behind that decision?
So the bond has two primary purposes. The first is to make sure someone shows up in court after they're charged. So setting a high bond obviously will make sure someone comes back, because if they have to post the cash in order to be out of custody pending the resolution of the case, they're likely to come back because they don't want to lose that money. The second primary purpose is protection of the public, and that's to make sure that if someone is charged with an offense, that they're not a risk to the community. But bond is always balanced against the constitutional rights of the person who's charged, because they remain enjoying the presumption of innocence. Right now, she's presumed to be innocent, and the presentation of evidence by the prosecutor at the bond hearing was merely what he was telling the judge. This is what I think the evidence is going to show. But a criminal defendant in the United States is not only entitled to the presumption of innocence, but the right to confront and cross-examine witnesses that may be brought under the Sixth Amendment. And those rights are important. The presumption of innocence and the right to a trial and to confront and cross-examine are things that have to be weighed, because none of those have been resolved yet, have to be weighed against whatever the court and the prosecutor's arguments or interests are to make sure someone shows up in court or is not a danger to the community. So bail often is just striking a balance, making sure someone shows up in court while at the same time respecting and acknowledging that someone is presumed to be innocent, and we have to really weigh what we know at this point before things are resolved finally at trial.
Now, we are continuing to learn more information about this case, but just hypothetically, if it comes out that the family that was crossing the street was not in a crosswalk, does that affect the case at all? Does that help Fenton's case?
So criminally, it's unlikely to have a great deal of impact, because the criminal statute doesn't speak to whether or not the pedestrian was lawfully on the roadway. The only question on the criminal context is whether or not the person, after striking a pedestrian, left the scene, whether they were in a crosswalk or not. So it's unlikely to have any effect in the criminal context. As to any civil lawsuit, if there were to be a case filed against this woman or someone else that the family or Miss Bennett could articulate was responsible for what happened, that might come into play, because the civil laws for recovering money against folks who injure pedestrians like this would take into consideration acts or mistakes that the people who were injured made that had some cause as to what happened. So if someone's not crossing in a crosswalk, we know that is jaywalking, that can be contributed or attributed as negligence on the part of the person who was walking where they shouldn't have been, that could affect their ability to recover or how much they recover in damages. But in the criminal context, it's not going to matter.
Is there a possibility that Fenton could be offered a plea deal?
I would highly expect that that would happen in a case like this. Going back to your earlier question about her, claiming that she thought she hit a dog. I've been doing this a long time as both prosecutor and attorney. It's unlikely that that is going to play well in front of a jury, particularly because she drove back, and then when she drove back, then she drove away. If she really thought it was a dog, how the argument as a prosecutor you'd make is how likely is it that she would be in such a panic to drive away? The evidence far more suggests that she maybe initially at impact didn't know, because it's fair to assume she didn't see these people before the accident happened. But that once she drove back and saw, I mean, I don't know how you can mistake these, two young kids and a mom and a baby carrier as a dog, right? So the prosecutor's really going to argue strenuously this is really a nonsense explanation. It's unlikely, just from what we know, to carry the day, assuming everything is true that we know right now. And so, in that context, it's likely a plea deal is probably going to be pursued very aggressively by the prosecutor, because the chances at trial are not likely to be good for this defendant.
It took the police weeks to make an arrest. What challenges do investigators face in cases where the suspect has fled or allegedly fled? And what
Mhm.
resources do they rely on to solve these types of crimes?
So, in a case as serious as this, the police are going to be vigorous and thorough. They do not want to miss any evidence or information that they could develop in order to establish who committed the crime and the circumstances under which the crime were committed. And so, the first thing, anytime someone leaves the scene of an accident like this, the police always have on their radar to investigate whether the person, once they can identify a suspect, whether they were under the influence of something. That's the typical case in which someone flees is because they don't want to get arrested because they were drinking and driving or under the influence of drugs. So when the police are investigating these cases, they're not only really, trying to find out who did it, and I suspect in this case they probably found out pretty quickly who did it. There's traffic cameras that they could have captured the license plate leaving the scene. Typically, witnesses may have identified or described the vehicle. Someone might have even had a license plate to call back. So they probably knew pretty quickly who was involved. They needed to nail down then who was actually driving, which by itself probably wouldn't take much. But then they're really going to drill in is where was that person beforehand? What were they doing, in the hours beforehand, so they can establish whether or not there's more serious charges to be brought because someone was under the influence at the time that the accident happened. So from an investigatory standpoint, the thoroughness of what they're looking for, because there's so many things they have to evaluate, is going to take time. On a case like this where someone flees, they probably knew pretty early who it was, but they needed to put more information behind the case to establish any other charges that could have been brought, and that's likely why it took as long as it did.
How often do cases like this result in the driver being held accountable for both the fatalities and the serious injuries that they caused?
If they're identified, almost always. This is a situation where with the charges that she's charged with, they're very simple, straightforward elements of the crime. That you were driving, that you caused, that you struck pedestrians, and that you left the scene. So all the police and prosecutors really their biggest thing to prove is who was driving, that she was actually driving the car at the time. I assume that they have very strong evidence on that right now, because, as nowadays, if this lady had a phone, you can be sure that they've pulled all of her location information from her phone by a warrant or some other means. So they know exactly where she was, or at least where her phone was at various times relevant to when this accident occurred. So they're likely to be able to really put her on the scene if they haven't other witnesses who say, I saw her driving. I could see the person, I saw her face, I could identify her. So with all of those things, with the ease of what it takes to prove the case, as well as all of the tools that law enforcement has at their disposal to identify folks, It's unlikely that that she will escape accountability.
Given the serious injuries that Taeler Bennett sustained, how does the law handle situations where the victim survives but is left with long term effects from the crash?
Not well, unfortunately. There's limited tools that the law has to deal with that, because the primary source to compensate or to take care of someone who has permanent injuries that she may have, have to come from the defendant herself. So, her financial ability to pay restitution is really the main arm that the court has to try and help a victim who sustained this kind of injury. The civil laws then after that to try and get damage awards either through insurance or through this lady's personal assets is another way. But unfortunately, the law is somewhat limited in what it can do to make someone whole or to make up for the injuries that they sustained.
How might Fenton's age factor into her defense or potential sentencing? We know she's in her 70s.
So in terms of her defense, I could imagine some defense being offered in terms of, well, she couldn't see very well. She's an elderly lady. She can't hear very well. Things in terms of what would impair her senses based on her age as to what she knew, what she saw, and why she did what she did. Sometimes age can be offered as a factor to mitigate someone's punishment, where you say, well, they're elderly. If they get a lengthy sentence, it effectively will be a life sentence for them. Those things practically can be considered, but as a matter of law in Florida, age itself, an elderly age, is not a factor that a court is required to consider in mitigation. So I imagine that this lady's attorney is going to press heavily to the court to remind her that any lengthy sentence for her will amount to a life sentence, which is certainly not what the sentencing guidelines in Florida contemplated for something like this, because normally it's 4 to 30 years or more, depending on circumstances. But with someone who's 72 years old, it's very unlikely she'll see freedom after being sentenced with her age.
Do you think Fenton's apparent lack of criminal history will play a role in her defense or the sentencing?
It will be the primary defense argument for mitigation, is my expectation, because a lack of prior criminal history, coupled in this case with the fact that this wasn't an intentional crime. She didn't intend to harm anyone, but that her real offense was the fact that she did unfortunately kill two children and really seriously injure their mom. It really is going to be her best argument for mitigation to say it wasn't intentional, and she really any lengthy sentence will amount to a life sentence.
And let's go back to what Fenton's attorney said again, saying that she thought that she hit a dog and that's why,
Hmm.
she didn't come back and call for help. In your opinion, does that claim that she thought that she hit a dog seem plausible given the circumstances of the accident?
Yeah, I think I spoke a little bit about this before, but I think that the defense is going to have a very hard time to rely on that claim to defend the case, as if to try and get off and not be held accountable. I think that that's more likely to be something to be offered as mitigation, to argue to the court she didn't intend to do what happened, obviously, to kill people or to severely maim anyone, and because of that, the excuse was really just that it was a panic and just a fear, and I think everyone can sort of understand that just from the perspective of, if I was in that woman's shoes, what would be going through my mind and what would I be afraid of? Not that the law will ever, give that some credibility as an excuse or to, relieve her of accountability. But I suppose it's understandable from a human standpoint.
Well, let's just take a deeper dive into that. How do prosecutors prove intent or negligence in hit and run cases like this,
Mhm.
especially when the driver claims that they were unaware of what they hit?
So intent is always a harder thing than negligence, because negligence is just a function of what you should have done had you been doing things properly. So this case is an automatic negligence claim because you can show she was careless. because obviously hitting people on the road means that you weren't watching where you were going and what you were doing. From an intent standpoint for the criminal statute showing that someone did something willfully, if this was a murder charge, it would be very hard to prove an intent to kill here, because you'd have to, the prosecution would really have to articulate some motive as to why she would have wanted to kill, two children, or to hit a mom walking with her babies. You can see how hard something is to prove, like intent to kill. This case is not anything like that level of intent that the prosecutor has to prove. It's just that they willfully left the scene after they knew that they had hit something. And that's effectively, it sounds like, if the evidence comes in as the way that it's been presented so far and it winds up being true, I think the prosecutors are going to be able to prove that fairly easily. Because if her excuse is, "I thought I hit a dog," within that excuse is the acknowledgement, "I knew I hit something and I left the scene." So I think that from just in this case specifically, prosecutors won't have a difficult time. Generally, Kennedy, I can go on for at hours talking about how hard it is to prove intent in different cases, because it really depends on the facts and circumstances of the case. But from a prosecutor standpoint, they do that all day long, all week long, and they know how to do it well.
And lastly, the family of the victims, they now have to deal with the aftermath of not only the loss of the two young children, but also the life-threatening injuries to the mother. What legal recourse does the family have in holding Fenton accountable?
So, well, the first is the criminal justice process. And so obviously the outcome of this process will include, if she's found guilty or pleads guilty, some amount of restitution or something financially to unburden Ms. Bennett and her family from the cost of what's happened. Civilly, Ms. Bennett and her family will have the ability to pursue a lawsuit or an insurance claim to recover additional funds to offset and compensate for the tragically unfortunate circumstances that happen here. But that's really it. It's the criminal justice and the civil courts processes that are the tools that are available to their family. And, God willing, they get as much as they can.
Right. Well, this is a story that we will for sure be following. Thank you so much for coming on, Patrick.
I'm very happy to do it. Thank you very much for having me, Kennedy.
Law&Crime reached out to Fenton's attorney for a statement, but they said that they cannot comment on pending cases. According to Fox 13, Fenton will not be allowed to drive and will be required to wear a GPS ankle monitor while she's out on bond. For Law&Crime News, I'm Kennedi Walker.